Good morning, Mr. Papa.
Good morning, Judge Martin.
How are you, sir?
I'm okay. How are you?
I am wonderful. Have you spoken to the Claibornes?
No, if we can get a breakout room though, that would be great.
Absolutely. Marianne will get you in right now.
Thank you.
Good morning, Mr. Biggleman.
Good morning.
How are you, sir?
Good. Nice to meet you, Your Honor.
Good to meet you. My rule is about 15 minutes after the scheduled start time. If the Kennedys have not logged on by about 9:15, I'll call the case and get you on your way. Okay, sir?
I appreciate it. Thank you, Your Honor.
You're welcome. Oh, here they are. Here he is, Mr. Kennedy, for the bails. Mr. Kennedy,
Yes,
would you like to speak to Mr. Biggleman?
sure.
Marianne will get you in the breakout room. When you come out, I'll get your case called and get you both on your way.
Thank you.
Great, thank you.
Marianne, I made my note to myself last week for trial dates for anybody who's ready for that.
Oh, okay.
And then we have our next civil date is October 4th. I'm looking at October 4th in the afternoon for trials. October 4th in the afternoon, or October 18th during the day. I don't see anything scheduled for us. October 4th and October 18th.
Yeah, I don't see anything on the afternoon of the 4th either.
So I'll use the 1, 2 o'clock for trials, and then on the 18th, we just have, not just have arraignments, we have arraignments, so I would schedule trials throughout that day.
October, really? I'm just thinking, it just sounds so funny to hear it. It's just a month away.
Well, somebody yesterday morning was posting about going to the cider mill and whatnot, and I figured it's already that time of year. I wasn't even, my mind wasn't right for it. November 5th.
Oh, no. Oh, listen to that. Mom and I went to Home Goods and they have Christmas decorations out.
I was looking for a Halloween costume and they're sold out of this, that, and the third. And I'm like, it's only the first week of, well, second week of September. November 7th. The 15th, November 15th. What do we have going on? That might be a. And I'm trying not to schedule when other people have they're civil days, so civil department's not overloaded, but sometimes it's unavoidable. Let's look and see. Oh, we have a trial that day at 11 a.m. Huh,
What day?
November 15th. Okay, I remember this case. Okay. Do, 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 do. And I told Andy that when Mr. Nunley is ready, I'll take a break in the civil docket to do the felony cases.
Okay.
So when you see those files, or if you see Mr. Nunley pop on, that's how we're going. The civil stuff has to wait for them. This is 220-143-GC. This is Vision Restoration Building Company versus Wayne Bales and Kimberly Bales. May I have your appearances, please?
Jeffrey Bigelman on behalf of Vision Restoration Building Company, Inc.
Yes, Jeremy Kennedy on behalf of the defendants, and just would like to note for the record, Kim Bales passed away back several months ago. But so at this point, I'm representing Wayne.
Thank you for the update, Mr. Kennedy. The parties have had an opportunity to speak. This case was originally a small claims case that was removed to the general civil docket. This is the first appearance on this court's general civil pretrial docket. You've had an opportunity to speak. Mr. Bigelman, how are we proceeding this morning?
We would request 90 days discovery and then a status conference in 90 days. Both of us are open to ADR. We just need to speak to our clients as far as cost, timing, so forth. It's our goal to resolve this either on our own or with the assistance of ADR. And we're going to try not to have a jury trial in your court, Your Honor.
90 days discovery starts today, cuts off on December 5th. There is one of our judges here is a certified ICLE trained mediator. If you want to go that route versus going outside of the building, I leave it up to you. If that's something you want to discuss, and I can put you on track to be scheduled with Judge Green for mediation, unless there was some different type of dispute resolution you were interested in.
I would be open to that, Your Honor.
Yeah, I think that would be fine. It's fine, certainly fine with me. I'm sure it'd be fine with my client, but I'll talk to him, but I think that'd be a good way to go.
Okay, so 90 days discovery starts today, closes on December the 5th, 2022. We actually have our civil docket that very next day, December the 6th. We'll call it final pretrial. You can also do your motions that day, December 6th, 2022 at 9 a.m. I'll send the file over to Judge Green, who will reach out to you to schedule for mediation. And then would think that you should be able to have that done sometime in November. I'm trying to think to give you enough time to get it scheduled with her. I don't want to have it too early so that you don't have your period of discovery. So 90 days discovery, schedule mediation with Judge Green, let's say late October to early November. And that should give you some time to get discovery going. Have you back with me for final pretrial motion on December 6, 2022 at 9 a.m. We are proceeding on civil cases still by Zoom. if you need more time to get scheduled and meet with Judge Green, she'll return the file to me. And we'll just adjust the dates for your final pretrial and motion. Anything else, Mr. Biggleman?
Just for clarity, December 6th, you want the motions, if there are any, to be filed by that date or heard by that date?
I would think heard on that date. I don't know that it would take 90 days discovery on a case that's now been pending since January 22nd, January 13th of this year. Do you anticipate, Mr. Biggleman, needing the full 90 days to complete discovery, or would you think, are you looking for a longer date to file motions?
If we could have that date as the date to file motions, that's what I would request. Otherwise, we'd have to file it 30 days prior to that, which would bring us to November 6th.
So final pretrial on the 6th at 9 a.m. and that be the December 6th be your motion filing cutoff date, which will put the hearing date into the first. If there is a motion, the hearing date would be that first Tuesday in January of 23. Ugh. Wow. I don't even want to think about that. For scheduling purposes, Mr. Biggleman, this courtroom number 1 does civil cases on the first Tuesday of the month.
Okay, thank you, Your Honor.
Is it clear? Okay, anything else, Mr. Biggleman?
No, Your Honor.
Anything, Mr. Kennedy?
No, Your Honor.
Thank you much. Have a wonderful afternoon. I'll get the file over to Judge Green for mediation.
Thank you. Have a good day.
Thank you, Your Honor.
You too. Thank you. Ms. Millspa? I have not seen the attorney yet for Westland Car Carrier case is scheduled at 9:15. I anticipate they'll be here momentarily. If they're not here by 9:30, I'll call the case so you can get on with your day. You're muted. Mm-mm.
My kids, I'm at school and it's the first day of school and it's all in classes and everything all ready to start. So I'm just gonna sit here.
Okay. I saw the bulletin board behind you and I know today is the first day of school, so.
And I'm the gym teacher, so I have a great big huge gym with nobody in it yet.
Okay, thank you.
You're welcome.
Mary Ann, I can't even envision that we have to contemplate scheduling things in January. Holy smokes. Good morning, Mr. Nunley.
Good morning, Judge.
I'm not sure if Andy advised, we have a civil docket this morning, but I told her that as soon as you're ready on any of these 3 cases, we'll get your cases called so that the in custodies can take precedence.
Okay.
Thank you. Good morning, Mr. Cox.
Morning.
How are you, sir?
I'm doing very well.
Ms. Millspa is here. Would you like to speak to her before the case is called?
Yes, actually, that would be great.
Mary Ann will get you into a breakout room. Thank you. Mr. Pellegrini said, I'm going to keep showing up until my case is called. Good morning. How are you, ma'am? Wonderful. Thank you. Andy just came through the side door, and I'm so unaccustomed to seeing that door open. That's usually the prisoner transport.
Oh, yeah.
That's why I had kind of. September 6th. Mary Ann, I'm telling you, these days are flying by. Good morning, Mr. Pellegrini. Good morning, Van Buren.
Good morning.
They're gonna move Mr. Holly into a breakout room to talk to the MIDC attorney, okay?
Very good. Thank you.
You're welcome. Good morning, Mr. Goldhouse.
Good morning,
How are you, sir?
Leonard. I'm here for Discover Bank.
With Daniel Pellegrini.
I see him on the screen.
Would you like to
His
speak
name.
to him before the case is called? Mr. Gothels?
Yes, Your Honor, I'm sorry.
That's okay. I said, would you like to speak to him before the case is called?
Oh, actually, in this case, Your Honor, no, I would not. I'm here to ask for an adjournment of the pretrial. There's a dispute going on.
Hold on for one moment then.
Certainly.
Mr. Pellegrini looks to be frozen. Hold on, see if we can get him. Mr. Pellegrini? Mr. Pellegrini?
It looks like he's muted.
He's been here since 8:05. So let's see if we can get him going. This is 223018 GC. This is Credit Acceptance Corporation versus John Claiborne and Carrie Claiborne. May I have your appearances, please?
Good morning, Your Honor. Alexander Popov appearing on behalf of plaintiff PA 4378. Mr. Claiborne, just go ahead and say your name.
His audio is not connected.
Oh.
Oh, here we are.
There we go.
There we are. State your name for me, please, sir.
John Raymond Claiborne.
And where is Carrie Claiborne?
She unfortunately didn't have any personal time to take, so she is at work.
You've had the chance to meet with the attorney for credit acceptance, Mr. Popov. How are we proceeding this morning?
Your Honor, so we agreed on a consent judgment. I was just curious how you wanted to proceed on that issue exactly with Mrs. Claiborne. We did enter or agree to a consent judgment. It looks like she wasn't, I don't see any service. I see service for Mr. Claiborne, but she is on the answer to the complaint.
If she submitted herself to the court by signing off on the answer and you have a consent judgment, I'll take the terms. And if you wanted to submit it to them electronically for signature or submit it 7-day, you tell me how you wanted to proceed.
If we can just say the terms on the record, then I can submit a 7-day order if that's okay.
The terms?
Yep. The consent order having been reviewed by the parties and the representatives, the court noting the stipulations of the party below. It's hereby ordered that the total amount owed on the defendant's account is a principal balance of $13,881.31 plus court costs in the amount of $160, service fees of $68.12, and a statutory fee in the amount of $75 for a total balance of $14,184.43. That judgment by consent shall enter against defendants John and Carrie Claiborne for $14,184.43 with statutory post-judgment interest accruing at 13% per annum. That defendants shall pay the plaintiff the judgment amount in monthly installments of $50 per month starting September 15th, 2022. Defendants shall continue to pay $50 per month on the 15th of every month until the balance is paid in full. If the defendants fail to abide by the terms of this consent judgment, plaintiff shall submit an affidavit of non-compliance with the court, whereby the terms of this agreement shall be set aside without further court hearings. Plaintiff will then pursue the regular course of collections on its judgment in its entirety.
Mr. Claiborne, were you able to hear the terms that Mr. Popoff just placed on the record?
Yes, we went over them before we came into the courtroom, and hearing them now, I completely agree with it.
I'm sorry, you said you are in complete agreement?
Yes,
Because you are appearing by Zoom and there is not a signed consent judgment in the file, Mr. Popoff's office will prepare it and submit it to the court. Our shorthand way of referring to is by 7 days, which means he'll send it to the court. He'll send a copy to you as well, and you'll have 7 days to file your objection to it. Your objection would be that it did not contain the agreement that you reached with him this morning. If the court received that, we would schedule it for hearing. If the proposed consent judgment that his office submits is exactly what you wish to agree to, including the $50 per month payment terms, you don't need to do anything. The court will sign it and a copy will be mailed to you. Understood?
understood.
Any questions, Mr. Claiborne?
Not at this time, no.
We are all set. You both have a wonderful day. Thank you.
Thank you, Your Honor.
This is 220620 FY. This is State of Michigan versus Richard Lewis Holly. May I have your appearance, please?
Royce Nunley appearing on behalf of the defendant, Your Honor. We would waive a formal reading and ask the court to enter a plea of not guilty on Mr. Holly's behalf.
Mr. Holly, state your name for me, please, sir.
My name is Richard Lewis Holly, Hollie.
Mr. Holly, you had the opportunity to speak to Mr. Nunley this morning.
Yes, ma'am.
He has waived the formal reading, asked the court to enter a plea of not guilty on your behalf. Sir, in this felony matter, you have a right to be represented by an attorney. If you're unable to retain an attorney through your own resources or that of family or friends, the court may appoint one for you. Attached to the front of your file is a petition for court-appointed attorney. The court has signed that, and you'll be assigned an attorney going forward. Mr. Nunley will not be that attorney. It will be somebody else. They will rely on the phone number and email on your petition for attorney to reach out to you to provide the representation that you're seeking. Sir, you also have the right to be considered for pretrial release. There is a recommendation from Van Buren Township that your bond be set at 10,000, 10%. Mr. Nunley, your comment as to bond in this matter.
Yes, Your Honor, we would ask the court to consider a personal bond in this matter. Simply put, he does not have any money. Any sort of bond amount is going to guarantee that he sits in jail until his next court appearance. He is not currently on probation or parole. He did indicate that he has a warrant out of Utica, but he did also indicate to me that he was not given notice and he was unaware that he was supposed to be in court for it. He is living currently in Detroit with his parents. Besides this issue that's going on out of Utica, I asked him if he had any sort of a history of failure to appear to court appearances, and he indicated to me that he does not. However, he does not have any ability to post a cash bond. He said he's been sitting there since about Friday or Saturday, so I would ask the court to consider a personal an opportunity to get out during the pendency case.
Thank you for that. Mr. Nunley, and respectfully, the court will not enter a personal bond in this matter. Mr. Holly has a criminal history that goes back 24 years that involves some of the same things that are alleged in the case before the court today. His bond will be set at 5,000, 10%. The next step in these proceedings, Mr. Holly, is your probable cause conference, which will be on Wednesday, September the 14th, 2022 at 8:30 a.m. in courtroom number 2 with Chief Judge Brian Oakley. Again, this case number is 220620. Next appearance date, September 14th at 8:30 a.m. Anything else in this matter, Mr. Nunley?
Nothing further, Judge.
Thank you. Mr. Holly, have a good day, sir.
Thank you, ma'am.
I believe that Mr. Robinson is here now, Mr. Nunley.
Okay.
Mr. Pellegrini. Marianne, it looks like he was asking for the phone number to call in the Zoom, and I don't have it. If you have it, or Andy, if you have it, would you chat it to him, please, so he may join us?
I can send the audio dial in. Judge, who did you want me to send it to?
Mr. Pellegrini.
Thank you.
His audio is not connecting, but he's ready. Good morning, Ms. Francis.
Good morning, Judge.
I don't believe that I see your other side.
Okay. I'll just
Ms.
wait.
McKinney?
Yes, ma'am. Good
What are
morning.
you here for, ma'am?
There was I found out there was a bench warrant from 2016, I believe. I was pulled over in Belleville, and I found that out from Fairway at Gateway, the association.
Ms. McKinney?
Yes, ma'am.
Are you scheduled to be in court this morning?
Yes, ma'am. September 6th.
Do you have your notice to?
Do I have my notice?
Yes, ma'am.
Yes.
The case number on that notice, please, ma'am.
157136.
Ma'am, you are not.
scheduled to appear. Oh, okay. Yeah, I've been trying to contact the opposing counsel.
No, Mr. Strauss, stop talking, please. Ms. McKinney?
Yes.
Oh, for the love of me. They have you, first they had you scheduled at 9:30 this morning. And then there was a satisfaction of judgment. The plaintiff's attorney has indicated that you have satisfied the balance that was due on the judgment. So they removed the hearing from this morning's docket.
Okay.
You
So
should
I'm all
have received a
set?
copy of that. The court received the satisfaction on August 1st. A copy would have been mailed to you, okay?
Okay.
Anything else, ma'am?
No, ma'am.
Have a wonderful day. Thank you.
Thank you, Your Honor. You as well.
This is 223024 GC. This is Westland Car Care Towing versus Gale Mill Spa. May I have your appearances, please?
Good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
State your name for me, please, ma'am.
Gail Mill Spa.
Today is the day and time set for the pretrial in this matter. The parties have had an opportunity to speak. Mr. Cox, how are we proceeding this morning?
Yeah, Judge, we might need an adjournment of this matter. This is a towing case where plaintiff seeking towing and storage charges from and Miss Millspaw was identified as the last known registered owner. her contention is she sold the vehicle over a year before it was towed. However, what she's lacking is documentation to evidence the sale. I've requested of her that she draft an affidavit. She has another person who might be a witness, could also draft an affidavit and present those to my client to see if they want to continue to pursue the case despite the lack of the documentation. I think that might result in resolution. So I was thinking maybe a 30-day adjournment, Judge.
That 30-day, would that give you sufficient time to get that completed, Ms. Millspaugh?
Yes.
This case will be adjourned to October 4th, 2022 at 9 a.m. Back with me on Zoom in courtroom number 1. Anything else on behalf of Westland Car Care?
Not at this time, Your Honor.
Anything else, Ms. Millspaugh?
No.
We are all set. I will see you on October 4th unless you resolve it before that, okay?
Very good.
Okay.
Have a good day.
Thank you.
Mr. Pellegrini is still here.
Yes, I am, Your Honor.
Oh, wonderful.
I had to call in. I'm having some technical difficulties at home with my laptop.
It's fine. This is 222832GC. This is Discover Bank versus Pellegrini. May I have your appearances, please?
Good morning, Your Honor. Michael Gothals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
Mr. Pellegrini, state your name for me, please, sir.
Sure, Dan Pellegrini.
Today is the day and time set for the first pretrial in this matter. The court did inquire of Mr. Gothals if he would like to speak to you beforehand. He indicated no. And Mr. Gothals, how are we proceeding this morning?
Well, Your Honor, Mr. Pellegrini's dispute of this debt is under investigation by our client. And I would ask for an adjournment, say for 30 days, so they can complete that investigation.
Mr. Pellegrini, do you have any objection to an adjournment in this matter?
No, I do not.
This matter will be adjourned to October the 4th, 2022 at 9:30 a.m. back here in number 1. Anything else on behalf of Discover Bank?
No, Your Honor.
Anything else, Mr. Pellegrini?
No, Your Honor.
Thank you so much. You both have a wonderful afternoon.
Thank you. You
Thank
too,
you very
Your Honor.
much. You too, Your Honor.
Thank you.
Judge, on mine, we were just going to request an adjournment.
Is she here?
I don't think she'll appear. We did resolve it. We're just waiting for a signed consent judgment to be returned.
Give me a moment so I can call the case and then we can get you on your way. This is 221840GC. This is Citibank. First is Julie Laren. May I have your appearances, please? Your appearance, please.
Navjot Francis on behalf of Plaintiff's Attorney of Record.
Ms. Francis, you were making a representation to the court that there is a settlement document pending between the parties. Is that accurate, ma'am?
That is correct, Your Honor.
And is the defendant not expected this morning?
I am guessing not. We did send her a consent judgment. We were just waiting for a return.
The case was scheduled at 9:30. It is 9:39 by the court's clock. The defendant has not appeared as of yet. The court will take the representation of Ms. Francis that there is a consent judgment pending by and between the parties. Ms. Francis, if the court has not received it within the next 3 weeks, there will be this file will be placed on the no progress notice, on the no progress docket and re-noticed for entry of an order. Anything else, ma'am?
No, Your Honor. Your Honor, I do have a 10:30. I do have to get to a court at 10, so I just wanted to let you know in case I'm late for that 10:30.
If you're late for the motion for summary disposition?
Yes, the LVNV
Okay.
pending one.
Yes, ma'am.
Thank you, Judge.
I'll see you later. Thank you, ma'am.
Okay.
Mariana, hold on to Laren in case they appear. This is 220617 FY. This is State of Michigan versus Tommy Robinson.
Good morning, Your Honor. Royce Nunley appearing on behalf of the defendant. We would waive a formal reading and ask the court to enter a plea of not guilty on his behalf.
Mr. Robinson, state your name for the record.
Tommy Robinson.
Thank you. You had the opportunity to speak to Mr. Nunley this morning.
Yes, ma'am.
He's just indicated that he's waiving the formal reading of the charges against you and asking the court to enter a plea of not guilty on your behalf. Mr. Robinson, in this felony matter, you have a right to be represented by an attorney. If you're unable to afford one through your own resources or that of family or friends, the court may appoint one for you. There is a request for a court-appointed attorney attached to the front of your file. The court has signed that, and you will be assigned an attorney going forward. They will rely on the phone number and email that you've provided this morning to be in communication with you regarding this matter. You also have the right to be considered for pretrial release. There is the indication from the Sheriff's Department that they appear to take no position as to bond. It says at the discretion of the court. Mr. Nunley, any comment as to bond in this matter?
Yeah, so my client indicated to me that this case was dismissed by Your Honor on the 31st of August, and that they are just recharging this case. He did indicate that he is being held in county right now for some case that's pending out of Chicago. However, if that issue were to be resolved out of Chicago, we'd ask the court just to enter a personal bond on this matter so that he would be eligible for pretrial release.
Mr. Nunley, I'm pretty sure. Yeah, I'm trying to look back in the file. There was a recommendation from August 8th of this year that Mr. Robinson's bond be set at 30,000, 10%.
I don't have that. I don't have any information regarding that. I mean, I didn't even, obviously I didn't know he was charged before. He just told me that that the charge was dismissed recently, August 31st, and that
It was last Wednesday, my last Wednesday felony docket.
Gotcha. Well, I mean, from what I read from the very, very brief description they gave me, it just sounds as if there was a firearm found in a car after a traffic stop. So from what I can see, from what's available to me, I mean, it wasn't a violent offense, or he wasn't, committing any sort of act of violence at the time of the traffic stop. And, like I said, he's been in there about 30 days. So he's indicated to me from this issue out of Chicago. I don't know if it's going to be resolved, but if it does get resolved, I know Mr. Robinson would like an opportunity to be out so that he can, try to beat the charge for the second time.
Understood, Mr. Nunley, and I'm looking at the recommendation again from August 8th, and the request is 30,000, 10%. Based on prior failures to appear, his lack of a permanent residence or family ties or employment, the seriousness of the offense or probability of conviction, the fact that he's an out-of-state resident with a prior record and felony warrants out of Texas from 2016 and 2020. The bond previously had been 10,000. 10%. Mr. Robinson's bond will be set at 5,000, 10%.
Got it.
His next appearance date will be the probable cause conference on September 14th, 2022 at 8:30 a.m. And that will be in courtroom number 2 with Chief Judge Brian Oakley. Again, this case number is 220617 FY. Next appearance date, September 14th at 8:30 a.m. Anything else in this case, Mr. Nunley?
Nothing further, Judge. Thank you.
Thank you. Mr. Robinson, good luck to you, sir. Have a good day.
You too. Thank you.
Thank you.
That's the last one that I have for now. I'll keep my eye on my email in case any other ones pop up.
There's a third one. Todd Myers out of Huron, was he? I don't know if he waived MIDC. I don't have that information in front of me, Andy.
Yes, Judge Todd Myers did waive MIDC, and upon taking a second look at his cases, it is just a money issue. So we're going to send the department a payment plan.
Thank you. Thank you, Mr. Nunley.
Yeah, no problem.
Are the parties ready on Synchrony Bank versus Jackson?
Yeah, I'm Your Honor. Yeah. Yes.
This is 222032 GC. This is Synchrony Bank versus Glenn Jackson. May I have your appearance, please?
Good morning, Your Honor. David Canine, last name spelled C-A-N-I-N-E, P-1828, appearing on behalf of the plaintiff. Thank you.
And Gary Strauss appearing on behalf of Mr. Jackson, 48673.
Today is the day and time set for the first pretrial in this matter. Mr. Canine, how are we proceeding this morning?
Your Honor, I'd like to request a period of discovery. Parties are in the midst of negotiations as we speak, but I think we would benefit from a period of discovery. Thank you.
What's a bit, sir?
I'm sorry.
30 days. I said, what is a bit? 30 days, 60 days?
I'm sorry. Forgive me, Your Honor. 60 days. I should have been more specific and less colloquial. Thank you.
60 days of discovery. Discovery opens immediately, closes October 7th, 2022. With a return date of December 6th, 2022 at 9 a.m. That will be final pretrial and motion date. Anything else on behalf of the plaintiff in this matter?
No, thank you, Your Honor.
Anything else on behalf of the defendant?
No, Your Honor. Everything's fine.
Thank you so much. You both have a wonderful day.
Likewise,
Okay,
Your
thank
Honor.
you.
Bye-bye.
You too.
Bye-bye.
This is 222293 GC. This is JP Morgan Chase Bank versus Doreen Conrad. The matter was scheduled for pretrial at 9:15. It's now 9:49 a.m. by the court's clock. Neither party has appeared this morning. Case is dismissed. This is 222631 GC. This is Midland Credit Management versus Kristen Haskey. This matter was scheduled at 9 a.m. It is now 9:50 a.m. by the court's clock. Parties were last here on August 2nd, indicating that a consent judgment would be filed. The court has not received anything disposing of this matter. Neither party has appeared this morning. This case will be dismissed. Good morning, Ms. Gleason.
Good morning.
Have not seen the attorneys on your case as of yet, but if you sit tight, as soon as they appear, we'll get the case called and get you on with your day, okay?
Okay, thank you.
We're just waiting for Mr. Burke.
Thank you, Your Honor.
You're welcome. Good morning, Mr. Burke.
Good morning, Your Honor. Sorry for my 5-minute absence. I was getting off another Zoom call.
Mr. Vonchek is in with his client. Did you need to speak to him this morning?
That would be great. And it looks like I have some others. Oh, not on your docket. That would be great if he and I could talk. Thank you.
You're welcome. This is 220503 GC. Excuse me, this is Beaumont Health versus Tiffany Fleeson. May I have your appearances, please?
Yes, thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
John Ivanchek on behalf of Tiffany Fleeson, who's also present, Your Honor.
Thank you. Today is the day and time set for the adjourned pretrial. How are we proceeding, Mr. Burke?
Your Honor, I think we're very close to being on the right track. Well, I know we are. And I believe that Mr. Ivanchek's client has done a lot of legwork to possibly get some of this reduced or voided. I'm told that she got an update on something like that very recently. I can make it my request. It can be both requests. It's permission of you, of course, Your Honor. I think within the next 30 days, we'll have an update as to what is reduced, what is going to be reduced or never going to be reduced. And then if we're left with some co-pays, that will get paid and resolved. So I guess it's our request if you'll adjourn it one more time, or if you think we just need a trial date. That being said, I believe the case will be resolved well before that. And Mr. Ivanchek can answer that or critique what I just said, of course.
I'm in agreement with counsel. I think an adjournment should give Mr. Burke time to figure out what his client or what's been updated, what's been billed, and for payment received from the insurance companies, Your Honor.
And give Ms. Fleeson some time to continue with what she believes should be reduced. Sounds like she's working hard on that.
Yeah, she has been since we were last year, Your Honor.
We will actually call it a final pretrial.
Okay.
Excuse me, on October 4, 2022 at 9:30 a.m. back on Zoom, back with me in courtroom number 1. If there are issues outstanding at that point, the court will be looking to schedule it for trial, and that trial day would likely be the first week of November. So whatever Ms. Fleeson is able to reduce down, and if you can come to some agreement regarding co-pays or any uncovered expenses, we can discuss that at the October 4th date in lieu of a trial in November, okay?
Thank you. Is that at 9:30, Your Honor, you said?
It is, sir.
Okay, thank you.
Thank you. Anything else, Mr. Burke?
Nothing. Thank you, Your Honor.
Anything else, Mr. Vanchek?
No, Your Honor, thank you.
Thank you, Ms. Fleeson. Good luck to you, ma'am. Have a wonderful afternoon.
You too. Thank you.
Thank you.
Have a great.
Mr. Mahmood.
Yes. Good morning, Your Honor.
Good morning. This is 220460 SC. This is Sabah Mahmood versus Royal Jordanian. Your name, please, sir?
Yes, Sabah Mahmood.
Thank you. Today,
Okay, I'm sorry.
that's okay. I'm sorry. Today is the day and time set for hearing on the defendant's motion to set aside the default judgment. This matter was scheduled at 10 o'clock. It's now 10:14 by this court's clock. My policy is 15 minutes after the scheduled start time. We're close enough by my account. Royal Jordanian has failed to appear this morning. For that reason, their motion to set aside will be denied. Anything else, Mr. Mahmood?
No, Your Honor.
Thank you, sir. We're all set. Have a wonderful day.
Thank you. You too. Have a good one.
Thank you.
Bye-bye.
This is 215981 GC. This is LVNV funding versus Doretha McIntyre. May I have your appearance, please, ma'am?
Good morning, Your Honor. Najat Francis on behalf of plaintiff's attorney of record.
Ms. Francis, this is the day and time set for the motion for summary disposition. It was scheduled at 10:30. It's now 10:43 by this court's clock. Ms. McIntyre has neither filed a response to the motion nor appeared this morning. How do you wish to proceed?
Your Honor, we would request for our motion for summary disposition to be granted.
The defendant having failed to respond or appear this morning, the plaintiff's motion for summary disposition will be granted. I'm just looking through the file to see if a proposed judgment was
They
submitted.
usually don't submit one, Your Honor. We could submit one under the 7-day rule.
Yes, ma'am. Thank you very much. Anything else in this matter?
No, Your Honor. Thank you.
Thank you. Have a good day.
You too.
Mary Ann, that concludes our docket for the morning. When I was downstairs, Andy indicated there was nothing else pending. If that remains true, Andy. Mary Ann,
Yep.
we'll take down our courtroom. If something comes up, we'll just log back on.
Okay, sounds good.
Thank you, ma'am.